Hello, everybody. It's wonderful to have such a great showing today. I'd like to welcome you to our event, Bush v. Gore, 15 years later, the Supreme Court and American Democracy. I'm Caroline Fredrickson, the president of the American Constitution Society. I'm so happy that you were able to join us today. I'd very much like to thank, before we get started, Julie Fernandez and the Open Society Foundations for hosting us here today in this wonderful space. And for any of those in the audience who may not yet be familiar with the American Constitution Society, we are a nationwide network of lawyers, law students, judges, policymakers, and scholars who believe that the law should be a force to improve the lives of all people. We work for positive change by shaping the debate on vitally important legal and constitutional issues through the development and promotion of high-impact ideas to opinion leaders and the media, and by building networks of lawyers, law students, judges, and policymakers dedicated to those ideas, and by countering the activist, conservative legal movement that has sought to erode enduring constitutional values. And while we cover a wide range of issues in our work, today's program focuses on two of the most essential: voting and judicial integrity. Today, we revisit the Supreme Court decision that just 15 years ago halted the counting of ballots in Florida and effectively decided the 2000 presidential election in favor of George W. Bush. Our panelists today will discuss the Supreme Court's equal protection ruling in Bush v. Gore and the impact it has had on election law and equal protection jurisprudence. They'll discuss critiques of the Supreme Court's actions and whether those actions had a lasting effect on the public's confidence in the Supreme Court as an institution. And they'll discuss the litigation that followed and that sought to vindicate the rights of individual Florida voters. And finally, they'll discuss where we are now, 15 years later, and less than 1 year from another presidential election. So here to moderate today's discussion and to return us to the days of hanging chads and butterfly ballots, I know you're excited, we have Joan Biskupic, who is the editor-in-charge for legal affairs at Reuters News. Joan has covered the Supreme Court for 25 years and written several books, including Breaking In, The Rise of Sonia Sotomayor and the Politics of Justice, and American Original, The Life and Constitution of Supreme Court Justice Antonin Scalia. She's also the author of Sandra Day O'Connor, How the First Woman on the Supreme Court Became Its Most Influential Justice. And before joining Reuters in 2012, Joan was the Supreme Court reporter for The Washington Post and for USA Today. She's been a regular panelist on PBS's Washington Week with Gwen Ifill, is a graduate of Georgetown Law School, and was a finalist for the Pulitzer Prize in 2015. So please join me in welcoming Joan and our esteemed panel for today's conversation.
Thank you, Caroline, and thank all of you for coming here today on unusually warm and to commemorate in several ways there it is, okay. To commemorate the 15th anniversary of what some of us feel like was just yesterday. I remember where I was. Obviously, I was in the press room, but I even remember where I was on December 9th, exactly when I heard on the radio that the justices had stopped the recounts. I was driving down North Capitol toward the court when I heard what had happened, and as some of you might feel in this room, that was almost as momentous as what the justices end up ruling, because in some ways, some of us might believe that that set the stage for what was going to happen on the 12th. But just think of, when we think of how eventful those 36 days were between the November 7th election and the final result in Bush v. Gore, we have to think of what's happened since. George W. Bush took the White House. We had the wars in Afghanistan. We had 9/11 just a few months later. We had the wars in Afghanistan and Iraq. We had a change in the Supreme Court in 2005 with Chief Justice John Roberts. 2006, Samuel Alito. We had the historic election then of Barack Obama, and then 2 more changes with Justice Sonia Sotomayor in 2009 and Elena Kagan in 2010. And in some ways, in 2010, Citizens United has replaced Bush v. Gore as a bit of a rallying cry, politically at least. Yet Bush v. Gore endures for many of us. And when I think people have stopped thinking about it or stopped asking about it, I'll give a speech somewhere, as in just last summer in Connecticut, where the first question was, and what about that Bush v. Gore? So it endures, and admittedly from folks mainly on the left. But we're here today to take into account both sides and look at not just what happened back then, but how the ruling has reverberated through the years. And joining me, I'll start with my immediate left here, Judith Browne Dianis, co-director of the Advancement Project. She was on the ground in Florida and has been on the ground ever since to ensure voting rights. A more exhaustive biography of all the panelists on the sheets that you've got. Next to her, we have Rick Hasen, University of California, Irvine law professor and a prolific writer on election law. Just this morning, crack of dawn, he sent 2 more pieces that he had just written commemorating Bush v. Gore. And I think probably, Rick, your name, if we Google Bush v. Gore, your name comes up like second with that, along with Justice Scalia saying, please get over it. And then next to Rick is Pam Karlan, professor at Stanford and a co-director of its Supreme Court litigation clinic. She's also written widely on Bush v. Gore, and like Judith, has been in the trenches, most recently as an assistant attorney general in the Civil Rights Division. And then Curt Levey, who's generously decided to stand in for Nelson Lund, who had been scheduled and wasn't able to make it. We really appreciate your coming because you're probably the person who will most defend the ruling in Bush v. Gore, and we need to hear your voice today. He was longtime executive director of the Committee for Justice and now is executive director for FreedomWorks Foundation. He's supported many of the Republican appointments through the years to the Supreme Court, and as I said, will probably be our real defender of Bush v. Gore among the panelists, and their fuller bios are in the material. I thought I'd start kind of in a briefer, breezier way, just to get all of our voices heard before we dig into the real substance. I wanted to ask each of the panelists what really resonates. What do they remember most vividly from that period? Recall for us something that sticks in your mind, just to bring us back to it. I'm glad to see so many people in the room who I know were there at the scene and who remember what happened. But just for the few of you who are thinking, okay, who was there on the court? Because it's changed. Let me just offer as a reminder. It was a per curiam opinion, wasn't signed by anyone specifically, issued at about 10:12, 10:15 that evening. In the majority were then Chief Justice William Rehnquist and Associate Justice Sandra Day O'Connor, Antonin Scalia, Anthony Kennedy, and Clarence Thomas. Dissenting were the more liberal justices, of course, John Paul Stevens, David Souter, Ruth Bader Ginsburg, and Stephen Breyer. And in the end, what the majority said was the recount process, as it was described by the majority and as it was going on in Florida at the time, is inconsistent with the minimum procedures necessary to protect the fundamental right of each voter in a state recount. And then it said, again, the implication was this is one ticket, good for one ride only. Our consideration is limited to the present circumstances, for the problem of equal protection in election processes generally presents many complexities. There was plenty of heat on the other side, but I'll give a snapshot of then Senior Justice John Paul Stevens' dissent. Although we may never know with complete certainty the identity of the winner of this year's presidential election, the identity of the loser is perfectly clear. It is the nation's confidence in the judge as an impartial guardian of the rule of law. So I'll start with you, Judith. What do you remember from either those 36 days or that eventful evening?
Sure. Well, first, thanks for having me here today. It's great to be in this room with faces that I remember from 15 years ago, though they may look a little different over the years, but it is great. I mean, just thinking about Bush v. Gore, in some ways I get some hives thinking about that time. And for me, when the decision was handed down, I was in Florida. And the thing that actually I remember is 2 days after the election, actually 1 day after the election, on the Wednesday, my co-director, Penda Hare, called me and said, we need to get on a plane. And I remember saying to her, to do what? And she said, we're going to go to Florida. We're voting rights lawyers. We will figure it out. And got on the plane on Thursday. And I stayed there for probably the next 2 months, investigating what happened to African American voters. And so, while all of the, there should probably be a statute in Florida that goes, a statue of someone doing this. I was not looking at hanging chads. I was finding those Black voters. And so, so that's what I remember. And I just remember the intensity of being in labor union halls, where they were organizing lawyers from throughout the country. And they had so many lawyers that at some point they said to us, hey, we'll lend you some lawyers. And they actually lent us about 100 lawyers to help us fan throughout the state to find those Black voters whose votes weren't counted. So I'll stop there.
Thanks, Judith. Rick?
Thanks, Joan, and thanks to ACS for the opportunity to put this together. I'm actually shocked that there are so many people actually still care about this case, because it does seem that we haven't done much to improve our elections since that. But I'm sure we'll get into that topic a little later. So I was thinking back to the night of the decision in Bush versus Gore, and I was home in California, and like everyone else, I was watching on television. And I remember the confusion on CNN and elsewhere as to what exactly what was going to happen next. What did the ruling mean? And there was a lot of confusion. And it took about 20 minutes before the opinion was available online. I remember the Washington Post was the first one to have it online. And it was before before I had the election law blog. But we did have the election law listserv, which some people in this room I know have been on. And I remember emailing that opinion out. And I remember reading the opinion and tripping over what I consider to be the greatest understatement in Supreme Court history, which is the line that says, the only disagreement is as to the remedy. So you remember that line? They say, 7 justices agree that there is a problem with the counting. The only disagreement is as to the remedy. And I was thinking, for just about everyone in the country, the only thing that mattered was the remedy. And as a teacher of remedies, I thought, that's really the whole ballgame to everyone else. And we can talk about whether the equal protection holding was right or wrong, but the disagreement as to the remedy struck me as the most controversial part of the case. And of course, what ends up happening is that the Gore lawyers read the opinion, and by the next morning, Gore decides he's not going to go back to the Florida Supreme Court and keep going, even though some thought there was a little bit of a window to potentially do that. But that sentence still sticks with me today. And when I teach remedies, I talk about that your client only cares about the bottom line, does not care about the reasoning that gets you there.
Thanks, Rick. And I should just mention to all of you, we're probably going to just talk among ourselves for about an hour, but we'll have plenty of time for questions. So keep those in mind, and there'll be a roving mic for that. Pam?
So I, too, want to thank ACS for putting on this event. I want to go back before the decision, because what struck me most about the election in Florida was that it was absolutely clear by Election Day that more voters who had gone to the polls and cast a ballot thought they had voted for Al Gore than thought they had voted for George Bush. But it turned out that the law was powerless to deal with some of the biggest problems. The butterfly ballot, for example, all those boobies and zadies somehow voting for Pat Buchanan. And even Pat Buchanan knew those votes were not his, but there was no way of giving those back. The people who were struck from the rolls by a bizarre purge process that ended up striking several thousand Black voters for the rolls on the grounds that they were felons, simply because their names matched the names of felons, and they shouldn't have been struck at all. So that by the time we got to the litigation, the system was already so flawed that it was unclear whether any remedies would work. And that, I think, has struck with me more than virtually anything else about the case.
Thanks, Pam. Curt?
I think the two things that stick in my mind the most are really the beginning and the end. Election night, where it looked like Gore had it wrapped up, but we hung around the election party I was at, and I think we wound up sort of napping on the floor, and then were awakened a few hours later by the news that Florida had now been awarded to Bush. And I remember we wandered down to the White House just to see what was going on there. There were a few hundred people shouting. I don't even remember about what. And then maybe around 3 a.m. we got back to my office, turned on the TV, and it turned out that Bush hadn't won after all. It was going to be what looked like a long contest. So just the drama, the ups and downs of that night stick with me. And then that final day or two, when the case was argued and then decided. But even after it was decided, there was that window. I mean, we think of the case as having halted the process. I mean, it halted the recount as the Florida Supreme Court had ordered it, but it remanded the case and allowed for another recount. I guess the Florida Supreme Court would have had to change what it said about the 12th being a deadline. Now, granted, that wasn't a big window, but we didn't know until the next morning whether whether Gore was going to pursue it. So I just remember having the feeling at that time of like, oh no, I haven't barely been able to stand going through 36 days of this, and it may still drag on further. I don't think I could stand it. And then, of course, in the morning, we got the news. But that's what sticks in my mind.
Thank you. And I think we'll reverse order now to actually ask you, Curt, your organization, and you have long talked about the perils of judicial activism. And I think some people in this room and some of your fellow panelists would think that if ever there was an Exhibit A for judicial activism, this might be it.
I actually think it's a very bad example of judicial activism, unless you define judicial activism extremely broadly to say any case where the ideological biases and politics of the judges play a role, which is basically every hot button issue that comes before the Supreme Court. If you take that broad a definition, then yes. But I think of this more as sort of the more typical case that I described before the Supreme Court, where you really can make plausible arguments on either side. And let's face it, judges being human, their ideologies and politics play a role. Again, we see that with just about all of the hot button issues. So I see it more like that. I don't think it has the true hallmarks of judicial activism, which is a reasoning that cannot be plausibly grounded. I'm not saying the best argument, but can't even be plausibly grounded in the words or intent of the Constitution or a statute or its statutory construction. I don't think, I've certainly read the arguments on both sides. I think you can make an argument, certainly either way. And another hallmark to me of true judicial activism is where the court is effectively acting as a legislature to amend the Constitution or amend a statute, and the court went out of its way not to do that here. I mean, ironically, some progressives, that's their biggest complaint, that the Supreme Court said it only applies to these circumstances. But I think the court was trying to go out of its way not to be activist there. So, but I had hoped at the time that. Given the genuine outrage on the part of the left, I thought maybe it might be too strong a word to say, but that they'd learn a lesson, that it's about frankly how it feels when the court makes stuff up. But I don't know that anyone learned a lesson. I mean, I could certainly point to recent decisions. I mean, Bergefell being the most obvious, but I could point to plenty of examples where I don't think the left has backed away from activism, and I know you guys can point to plenty of examples where you think that's true. Citizens United being one of them.
Okay, the left.
Sorry, progressives. I'll try not to say the left.
Pam or Rick, you want to jump in and just counter that?
Well, I don't think the problem with Bush against Gore was that it was judicial activism. I think the problem with it was that it was bad judging. And I think the one place where I would say the Supreme Court jumped in too fast was the first case. That is, had the Supreme Court not jumped in the first time in the Bush against Palm Beach County canvassing case, the entire process might have looked very different by the time it got to the Supreme Court. It wouldn't have been as much of a mess. And the Florida courts would not have been boxed in the way that they ended up being boxed in by the Supreme Court's decision that suggested that the legislature had to be looked at in a very particular way with respect to counting of presidential election ballots. So I think had the Supreme Court stayed out until the Florida courts had really completed the process, there would not have been the arguable equal protection problem that the court saw, because all of the ballots would have gone through the same counting process, and there wouldn't have been any colorable claim that ballots were being counted differently in different parts of the state. At the end of the day, there would have been a kind of harmonization of the standard, and at that point it would have been clear that more people had tried to vote for Al Gore than had voted for George Bush, and the votes should be awarded to Al Gore. So I don't think the problem was activism in some sense, but of course I'm very skeptical of the idea that activism means anything when people talk about it other than saying, this is an opinion I do not like.
Thanks, Pam. Rick?
I went back for my 2012 book, The Voting Wars. I went back and I reread everything after a decade, and nobody comes out looking good. And I think everybody probably would agree that the problem we had or one of the problems we had in the Florida 2000 election was an out-of-control Supreme Court. People just disagree about which Supreme Court that was. Well, it was the U.S. Supreme Court or the Florida Supreme Court. You look at all of the decisions that were made, ideology played such a strong role, and in the heat of the moment, it was very difficult for anyone to be objective about it. One statistic I think is really interesting. Florida's ballots are public records, and so the ballots themselves were transported to NORC, an organization in Illinois, to have the ballots recounted. After everything's over, Bush is already president. And what they found was that on contested ballots, if the counter, someone who's hired after the fact by this professional organization, if the counter was a Democrat, they were much more likely to find a vote for Gore than if the counter was a Republican. And so it was such a heated political moment that it was hard for anyone to be objective even after the fact. And I think that in the heat of the moment, these things are so difficult that it suggests that the problems have to be solved on the front end, so that we don't have the purges that Pam talked about, so we don't have bad ballot design. And then, of course, there's the election administrator's prayer, Lord, let this election not be close. The margin of error was much larger than the margin of victory in this case. And I think I disagree with Pam. I don't think we know very well who the actual winner was. I agree that more people wanted to vote for Gore than vote for Bush. But in terms of the actual recount of the ballots, there was one study that I think it was the New York Times that did, that found that the only way that Gore would have won is if the standard that Bush had advocated for the recount of ballots had been applied. So it was really too close to call.
Yeah, and actually, just to piggyback on that, the newspapers that then had done the counting did come out and say in the end that the court hadn't decided the election, in effect. So did you want to jump in, Judith, before?
Well, I guess, so there's the decision, and then there's what happened and was ignored. And I think, the one thing that sticks out in my head is the 537, 537, that number. And from our perspective, while people were talking about this decision, while people were looking at the Chads, what they weren't talking about was that Black people in the state of Florida were ripped off, and that it was intentional. And so had the Democratic Party and the candidate decided that they were going to investigate the claims of African Americans, we probably would have had a different president seated. Because from our perspective, when we went down, and what was interesting is now everybody knows there are hotlines, election protection, et cetera. Back then, there was one hotline, and it was in Baltimore at the NAACP headquarters. And that day, there were two lawyers from Advancement Project and one lawyer from the NAACP answering that phone, that 1-800 number. And all of the calls were coming in from Florida. And so it was based upon that we went down to Florida, held a hearing to understand what had happened to people, and then started an investigation. And what we found was over time through discovery in the case that became NAACP versus Katherine Harris, was that the Secretary of State had actually engaged in intentional actions that took African Americans off of the rolls. The purge that happened, that hurt thousands of voters, legitimate voters. We had plaintiffs in our case who had voted for years, who had never been convicted of a felony, who were told that they were taken out off of the rolls because they actually had, because they had been convicted, and found out later on that there was no conviction. We had people who had voted for 30 years, and all of a sudden their names weren't on the rolls, not because of a purge around felony conviction, but they were given no reason. We had people who registered for this particular election who actually did not make it to the rolls, all of which is well documented in the Commission on Civil Rights report on voter irregularities in Florida after 2000. And had we decided that we were going to look at all of the issues instead of looking at hanging chads and butterfly ballots, we would have found that there was partisan manipulation of that election that landed in a different outcome than what should have been. So I'll stop there.
You know, I want to pick up later when we come back to what's happening now to the nature of the settlement from that case. But let me get one more thing on the moment. And I'm going to pick up from something for Pam Karlan that I'm going to bring her first back to a great Q&A she had. It was with Pam and then Judge Richard Posner, and it ran in Harper's at the time. And Judge Posner is talking about how close we were to a constitutional crisis and why the court had to come in. And he says, this may sound ridiculous, but I believe that it could have been very bad had the crisis remained unresolved at Christmas. And Judge Posner says, do you know who the president would have been on January 20th if we had had no resolution of the succession crisis by then? And Pam says, after Clinton left? And he says, Larry Summers. And then Pam says, the Treasury of the Secretary? Now that he's been named president of Harvard, maybe that would have been viewed as a good training for him as president. And Posner says, well, he was number 4. And Pam rightly says, Madeleine Albright was number 3 maybe, but ineligible because she was foreign born. And Posner says numbers 1 and 2, Dennis Hastert and Strom Thurmond, they'd have to have quit their jobs. And Pam says, because you can't be president and hold another office. And then Posner concludes, Hastert wouldn't want to quit the speakership to be acting president for a few weeks. And Thurmond, if he had resigned, would have given Democrats control of the Senate. So it's President Summers. You wanted that? Anyway, Pam, if you talk about the notion that we were close to a dangerous constitutional crisis that evening of December 12th.
So I don't think we were close to a dangerous crisis then, and what a list of potential presidents. It's really kind of a rogues gallery. You know, of course, there are some candidates that seem well matched with that group. I actually want to talk about a different part of that lunch that we had, if I can, and say I don't think we were close to a constitutional crisis at that point. We still had a month before the Electoral College was going to meet, and by that point we would have had a decision from Florida one way or the other. So, you know, I don't think it would have been a constitutional crisis. The part of the interview or the lunch, they actually, the idea was I would have lunch with Dick Posner and they would tape us having lunch, and then they ran this transcript. And so there's a later part of the tape where Jack Hitt, who was our host, said, well, how bad a decision do you think Bush against Gore is? I said, look, it's a bad decision, but it's nowhere near Korematsu. And Dick Posner did something that shocked me then, and you'll see why it's so relevant today, which is he said, well, you know, I don't think Korematsu was such a bad decision either. Which kind of staggered me. I do not think that we were near a constitutional crisis. I don't think, but one of the things that I thought was quite interesting about what happened after the Supreme Court ruled is it was very different than the first 2 super close elections in U.S. presidential history, the election of 1800 and the election of 1876. Neither of those elections was decided by the Supreme Court, and if the Supreme Court had tried to decide either of those elections, they would have been ignored. And what was interesting to me is the power and the capital that the Supreme Court had built up was such that once the Supreme Court ruled, Vice President Gore saw no way to challenge the court's ruling, even if he thought it was wrong. That is, the Supreme Court, building, I think, on its decisions in Browne against Board of Education and in the reapportionment revolution, had built up such capital with the American people that once it said, this election is over, everybody snapped to and said, this election is over. And I think that's the reason, in part, that we didn't have a constitutional crisis. The Supreme Court should have waited till all the ballots were counted to issue an opinion saying this election is over. And that's where the Supreme Court got things wrong. But I don't think we needed to have this decided by December 12th so that people would have a full 2 weeks of Christmas shopping before Christmas Day.
Well, Curt, I'll ask Curt to respond first, and then you, Rick. I guess I'm reminded of things that at the time Justices Kennedy and O'Connor said, who obviously were very necessary to have that per curiam opinion, is that they felt some urgency themselves, that they had to jump in, that that things were out of control, either constitutionally or on the ground. What is your response to Pam on that?
Well, I agree that things would have turned out differently in the 19th century, and I wouldn't mind going back to those times, not in terms of necessarily the values of the times, but in terms of the role of the court. Think back to how Lincoln handled Dred Scott, which is to say that it applied to the parties and did not bind others. And you see what happened after Obergefell. I mean, there was a lot of talk before the decision that that's how state and local officials should react, but that's not how they reacted. So clearly the court went from being, I would say, one of three equal branches to what can only be called judicial supremacy, even judicial tyranny. The idea that there can't be any remedy, no matter how absurd what the Supreme Court does, is if you really think about it, I bet you a notion that no one supports in this room. If tomorrow the Supreme Court just decided to, I don't know, invalidate the 13th Amendment, should we all just sit by and say, well, it was 5-4, but that is a majority. So the idea that there's no limit to what the Supreme Court should do, and we should just all sit back and take it, I just think that at the end of the day, almost no one really agrees with that.
Rick?
I was just thinking back to the part in the opinion where I believe it was Kennedy probably wrote this. We think the per curiam was Kennedy and O'Connor. The part that says it's our unsought responsibility. We had no choice. And of course, it came up on cert. The court didn't have to take the case. And it actually reminds me of a line in Citizens United where the court says, we've been asked to determine whether to overrule Austin. So, well, no, you weren't asked. You haven't been asked. You asked to overrule. They were actually asked for additional briefing on a question that was not before the court. And I think this is consistent, and we can bring in Obergefell here, that Justice Kennedy has this view that he has this responsibility to decide all of the nation's major questions. And I think if this would have gone to Congress, would that have been a crisis? Sure, it would have been a crisis. Breaking news on CNN, it would be a constitutional crisis. No, I think there would have been a vote. And the Constitution actually gives that power to Congress. They thought about this after 1876. They thought about it at the founding. They thought about what the rules should be. And it could have been a political decision. It might have been a decision that would have had a President Bush winning in the House and Al Gore casting the tie vote in the Senate for Joe Lieberman. I mean, that could have happened, but the decision was meant to be a political one and not one in the hands of the court.
Thanks. Judith, did you want to add anything? Well, then I think I'll turn to you just so you can fill in the blanks from where we left off on the Harris case, because that ended up in a settlement, and that's dictated, that was sort of the first of what we've seen through the years now of challenges to, restrictions at the ballot box, how people's votes are for sure counted in the face of some people challenging and saying, well, there's voter fraud out there. Tell us a little bit about how Harris resolved itself.
So after months of investigating. We actually filed the case actually in January of 2000 is when we filed the case.
2001?
2001, sorry. And it was filed against Catherine Harris and six of the counties and the Division of Elections. And the idea was, we were challenging basically everything that we had known that happened. From the purge, and people may remember that there were two companies involved, DBT, and so we actually added one of them as one of the defendants because we knew we needed some information about what Catherine Harris had instructed them to do. And then we also filed claims under the National Voter Registration Act because we found that people in motor vehicle offices and public assistance offices were also not being registered to vote. And part of this was that, this case really, the Harris case really for us was the first time in which we actually saw that there were these cracks in our democracy, and the way in which we administer elections really kind of came to a head, and that the Secretary of State all of a sudden had so much power that Americans didn't know how much power a Secretary of State had, nor did Americans really know how much power the individual election officials had. So you have 67 counties in the state of Florida that actually were running elections 67 different ways, and they actually still run elections that way. And so what we did was that we ended up settling this case looking at ways to fix the system. And so it was a proactive case. We really, knew that we did not want to file the case to actually impact the outcome of the election, but what could we look at moving forward? And, that kind of litigation actually led to the Help America Vote Act, in which provisional ballots, we didn't have provisional ballots back then. So people showed up and couldn't vote, and there's nothing we can do. So the Help America Vote Act actually helped put money into the states and into the locales for the machines that were needed to get rid of some of those bad machines that we all know about, but also to put in provisional ballots. We then were also looking at the state's purge and how they had done the purge. Choice Point got out of the business as a result of the litigation and the investigation. But this really that case really was the beginning of what we now call election administration. There's a whole field of organizations that do election administration, looking at local election laws, looking at how election officials are administering the elections, but also at the state laws. And then if we think about the Bush v. Gore case, one of the things that I think that I would take from that case that has had an enduring impact really is the court kind of reminding states that actually they are the ones to establish whether or not there is a right to vote and how that right to vote will be executed. And so that really did, I think it's just a reminder to them, and it opened up the floodgates to a host of voter suppression laws that we have seen since 2000. If we go back to the Indiana voter ID case, and then moving forward into voter suppression that we're challenging in North Carolina and other places. So this is the partisan lesson that we have learned out of Florida has carried on and endured, and we've seen laws being passed for partisan manipulation of voting, and really in ways in which you can see state legislatures passing these laws where you can shave a little off here, shave a little off there, and you might get to 537 votes. And so I think that is probably the legacy, but I also think that for civil rights law, while Bush v. Gore itself, that case, may not have had a big impact, it did underscore the problems that we see in elections that have civil rights implications.
Thanks. Before we go to the impact on the law itself, and I know Rick has really followed the jurisprudential value or lack thereof through the years. Pam, is there anything you wanted to add from the trenches in terms of some of the voting rights litigation?
Well, just to kind of highlight something that Judith was getting at, which is before 2000, you did not see in the previous decade a large popular argument that there was substantial vote fraud going on, and therefore we had to tighten up voting laws. And in the last 10 or 15 years, the idea that there is substantial vote fraud in the United States and that substantial vote fraud can be stopped somehow by restricting the ability of individuals to cast a ballot and to have it counted has just gotten huge purchase. So that the Help America Vote Act itself doesn't actually help that many Americans to vote, in part because although it allows for provisional ballots, it doesn't have any federal standard on whether those ballots should be counted or not. And so thousands of people will cast provisional ballots and think that that has given them the ability to vote, only to find out those votes don't get counted. The rise of voter ID laws, the cutbacks in various reforms that have happened over the last, say, decade or so, is almost all both a direct product, I think, of the environment that came out of Bush v. Gore. That is an environment in which there was deep distrust of the ability of people to vote, and this sense that large numbers of people were voting who shouldn't be voting, and the like. And the Supreme Court's refusal in Bush versus Gore to recognize a fundamental right to vote. They repeat the argument that there is no right to vote for president unless the state has given you that right. And then the Equal Protection Clause really only applies to the counting of the ballots and not to the access of people to the vote in the first place. All of that's a function of Bush versus Gore. And of course, we haven't mentioned yet one of the other pieces of Bush versus Gore, which is a kind of, I guess it's like the man in the high court, to kind of riff off of the man in the high castle, which some of you may have been watching, which is the question of the counterfactual, which is, as a direct result of Bush against Gore, we have a Chief Justice who, from his earliest days as a lawyer, has had a deep distrust of federal voting rights laws. And that itself has shaped the discussion and the decisions going forward, and is worth kind of keeping our eye on as we get into the discussion of the impact of the case, the broader impact of the case. That is not just on the election and not just on election law, but on everything that followed from that.
Curt, did you want to jump in there?
I think Pam is right that a lot of the concerns among conservatives about voter fraud do spring from Bush v. Gore. I can only tell you how it looked from the perspective of the conservative legal community. There was absolute horror at the perception that Bush had, in the view of many, that Gore had almost stolen the election by asking for recounts in 3 heavily Democratic counties, by them doing the Democratic precincts first in one of those counties and not getting to the Republican precincts. That left a lot of scars among conservative lawyers, a feeling that, wow, elections aren't sacrosanct. Progressives are trying to, make this as partisan as everything else, and we need to fight back. So, we can debate whether it was an overreaction or a commensurate reaction. I know we're not going to agree on that today, but that's definitely was the psychology. When I sat in rooms with other conservative lawyers, that definitely was the feeling and the motivation.
Judith, you want to jump in?
Yeah, I sure do. Because the idea that that the election was stolen when there was a Secretary of State, and I really think people should go back and read this report, this investigation by the U.S. Commission on Civil Rights. And actually, my colleague now at Advancement Project, Eddie Hales, was the counsel at the Commission on Civil Rights at the time and cross-examined Katherine Harris and others who were involved in the purge. And just incredible admissions by the company that was hired by the state to do this purge, in which the company knew that the purge was wrong and that it was going to lead to false positives, and that there were going to be people who would be purged who had never been convicted of a felony, and that the Secretary of State said it's okay, that she wanted to cast a broad net, that she wanted an 80% match on name, date of birth, and address, and that she knew that there would be people who had not been convicted of a felony who would be purged, but that is what she wanted done. And that despite having the experts there at the table telling her that this is going to create a problem, she went forward with it. And so that piece, not mentioned in Bush v. Gore, because again, the race claims were not part of that case. But the fact that we could create a whole image and myth around voter fraud based on a pseudo-stolen election, when in fact the people who were in charge were doing things that they knew would cast African Americans off of the ballot, is wrong. And we've had to endure this whole myth around voter fraud with no kind of evidence of it, with our colleagues at the Brennan Center always reminding us that you're more likely to be struck by lightning than to find a prosecutable case of voter fraud, right? That is what we're dealing with, and we're dealing with the aftermath of that when, in fact, the liability and the responsibility for this really laid at the feet of the Secretary of State and probably some other people that were working with her.
Rick, I know you want to address that, and then I'd like you to kind of go broader then about the broader impact of Bush v. Gore on election law, and, well, answer that first, and then I've got a question for you.
So I think the primary lesson that not lawyers but political operatives learned from the whole Florida 2000 election is that in a close election, the rules of the game matter. And so what we've seen since then, it started with partisan secretaries of state, and we continue to have partisan secretaries of state. No state has moved to nonpartisan election administration. Florida's actually made it worse by making the position appointed now rather than it's subject to the will of the governor. Wisconsin's poised to get rid of one of the few nonpartisan election boards in the country. So very, very partisan, our election administration, very decentralized, right? So the rules of the game matter, and what's emerged is red state election law and blue state election law. Because it turns out that casual voters, voters who have moved, voters who are not registered, voters who tend to be poor, minority voters, tend to vote Democratic. And so in red states, in red state election law, premised on exaggerated claims of voter fraud, we see moves to make it harder to register and vote. And in blue states, states like my state of California, where increasing Democratic majorities is good for the state, you see it's becoming easier to register and vote. And so rather than approaching this with a kind of from the position of nonpartisan election administration, that we need to ensure that all eligible voters, but only eligible voters, can cast a ballot that will be accurately counted. I mean, that should be something everyone in this room should agree upon. Rather than that, we have our election rules being set by partisans and being done in a way that is likely to help the political party that's in power. And I think that's really problematic.
Rick, I want you to step back. You have written about just about every election law case that's come up since, states and federally. And I believe the Supreme Court itself has only referred to Bush v. Gore once in the Arizona case, and it was Clarence Thomas.
Right. So someone, I just linked to someone who called the Bush versus Gore the legal Voldemort, the name that shall not be uttered.
But it has been mentioned in lower court cases. So why don't
Yes.
you just give us a little bit of the lay of the land?
Right. So the only time has been mentioned in the Supreme Court, the case has been cited in the Supreme Court, was in a Justice Thomas dissent in the Arizona intertribal case on an Article 2 point, on the other part of the opinion, not on the equal protection point. In the lower courts, initially some courts had given Bush versus Gore's equal protection holding some legs. So what does it mean to arbitrarily value one person's vote over that of another? So, for example, in parts of California, parts of Florida, where you had punch card machines, you were much more likely to cast a vote that wouldn't count than in other parts. Is that a Bush versus Gore violation? Or is it only a Bush versus Gore violation if it's using different standards in a jurisdiction-wide recount? Or does the case have no precedential value at all? Or is the case a due process case, right? So there's all kinds of theories floating out there as to what the case means. So for a while, there were some courts making what progressives called lemonade from lemons, taking this opinion and using it to force greater equality in how voters are treated. That kind of came to a stop. There was a 2003 case involving the California recall election that the ACLU tried to put on hold because of the punch card machines in California. It's a good thing that election wasn't close, because in Los Angeles County, where I live, 9% of the ballots did not cast a valid vote, yes or no, on whether the governor should be recalled, compared to Alameda County, which used electronic voting machines, and the rate was less than 1%. So a lot of votes were being lost. So it looked like for a while the opinion had legs, but then jurisdiction after jurisdiction, the circuit shut it down. But now, and this is the piece that Joan was referring to that I just wrote for the ACS blog, in the Sixth Circuit in the last few years, the Sixth Circuit, home of Ohio, the court has reinvigorated Bush versus Gore's equal protection ruling, including in cases involving the disparate treatment of provisional ballots. And so it wouldn't be a surprise to see there's already a case that's pending in challenging some of the cutbacks in voting rights in Ohio, could end up back at the Supreme Court, where the court could have to address the question, does Bush versus Gore have precedential value? If it does, what does this equal protection holding mean?
Thanks. You know, Pam, you had referred to Chief Justice John Roberts and his view of voting rights, and I'm reminded that, of course, he got on a plane right in November of 2000 at the request of Ted Cruz, which is so ironic now that Ted Cruz is bashing him, but it was Ted Cruz who called John Roberts and said, please come down here right away, and he did, and the now chief worked with that team and Ben Ginsburg and others from the Republican Party to try to craft their arguments. And I'm just thinking of where he's ended up, for example, in Shelby County. The 2013 ruling that cut back on Section 5, not Section 2, which had been in his sights for a long time. What kind of line do you see, if any, between Bush v. Gore to Shelby County, by way of the chief, maybe?
Well, a couple. I mean, the most obvious is that the composition of the Supreme Court at the time of Shelby County and its predecessor, the Namudno case, is in part a product of the 2000 election. Now, it's obviously very hard to figure out who would have been nominated because 3 of the justices who've been replaced since Bush v. Gore were voluntary departures from the Supreme Court. And so, as many of you know, justices do seem more and more to be timing those voluntary departures in various ways. I mean, obviously, the Chief Justice's departure was not a voluntary departure. He died while he was in office. Very hard to know who would have been president by 2004, but pretty clear, I think, that in 2005, if the Democrats had held the White House even through the 2004 election, that means even if the Republicans had won the 2004 election, John Roberts would not have been positioned as he was to go on to the Supreme Court. Because as a lawyer from private practice, he wouldn't have had the same profile he had as a judge on the D.C. circuit. And obviously, if the Democrats had held the White House in the 2004 election, John Roberts would not have been the nominee. If a D.C. Circuit member from Hogan and Hartson had been Chief Justice then, it would have been David Tatel. And that would be a very different court. We know that in part from the fact that he wrote the lower court's decision in Shelby County upholding the constitutionality of the Voting Rights Act. The Chief Justice's involvement in voting rights did not begin with his getting on a plane in 2000. He had been in the Justice Department during the Reagan administration and had been quite a skeptic then of the Voting Rights Act. Now, where do I think the big doctrinal move had been made in the interim? I think in part it was the Supreme Court's retreat from the idea that restrictions on the right to vote should be subject to strict scrutiny under the Equal Protection Clause to a sort of undue burden standard that they adopted for the actual right to cast a ballot and have it counted in the Indiana Crawford case that Judith alluded to earlier. And that allows for a great deal more fluidity and a great deal more flexibility, both in the Supreme Court and in lower courts, on whether to find any particular restriction on the right to vote to violate either the Voting Rights Act, where it comes into play in the question whether or not a particular law has a tenuous justification, and under the 14th Amendment constitutional right to vote. And so that's where I think the Bush against Gore case moves into the territory of the more recent cases by denying that there's a fundamental right to vote and by treating that right as something to be balanced and to be balanced against all of the interests that you've heard us discuss before with regard to claims of fraud and the like.
Curt, you've worked on these issues from the opposite point of view. What kind of comparison or line would you draw between Bush v. Gore to Shelby County?
Well, what jumps out at me is just sort of the contradictory arguments that I hear from progressives when we're talking about those two cases. One of the complaints that progressives make about Bush v. Gore is that the Supreme Court mismanaged something that was, shouldn't say mismanaged, micromanaged, and in their view, mismanaged, something that was largely a matter of state law. And yet, the preclearance section of the Voting Rights Act, that's all about micromanaging, about jumping in early and negotiating what what federal bureaucrats think is acceptable. And then also I've heard it, just on this panel today, several of the panelists have said, the Supreme Court's mistake was that it didn't let things proceed. It jumped in. Well, that's, again, exactly what preclearance does. I mean, preclearance not only doesn't wait for the votes to be counted, it doesn't even wait for the election procedures to be implemented. It's all about jumping in and second guessing. So, I'm not going to say which is right and which is wrong, but there's definitely a contradiction.
There's no contradiction there at all. And the reason there's no contradiction is that the preclearance regime is the product of the democratic process. It is the process that Congress enacted this law. And so to say that the court jumping in and claiming a constitutional problem is the same thing as Congress saying, we think there is a demonstrated problem. And the demonstrated problem is indicated both by the stuff that Judith talked about that happened in Florida, which was a state largely not covered by preclearance, which is why they could have these purges and why they could change the election laws in the way they did. And on the other hand, most of the vote suppression stuff that we're seeing today, huge amounts of that not only could be blocked by preclearance, but were blocked by preclearance before the Supreme Court struck down the formula for preclearance in Shelby County.
I mean, your argument is that the Supreme Court was interfering with democracy, but that was exactly the argument of the majority in Bush v. Gore, was that the Florida legislature had spoken, that it had a constitutional right to be the final word in this case, and that the Florida Supreme Court had, in a sense, overruled it. So it's exactly the same issue of democracy versus court second guessing.
Anybody else want to jump in? We're just about 2 minutes before we're going to go to questions, but go ahead.
Just on Shelby, first it's, there's a history about why we had Section 5, a robust Section 5, and why we needed federal intervention. We could read lots of books about that if we need to. Secondly is that, when Section 5 preclearance happens, the states actually do, they have the opportunity to provide information about the way in which it will play out. So it's not like there is no due process for a state before a court or the Department of Justice actually rejects it. So I think, this is not the same as saying, slow down, let the state actually get to the point where they count it. They count everything and then go to the court. It's a very different situation, and I think you're obscuring the difference.
Let me remind you that the Florida Supreme Court also had a chance. You're saying the states have a chance under preclearance to correct things. The Florida Supreme Court also had a chance. It was warned the first time that the legislature's power with regard to electors was plenary, and it ignored that and went ahead and overruled the legislature again. And so, again, I could make the same point that you're making on the other side.
Yeah, I'm going to let Rick jump in here now, too. But I think everybody here knows what Section 5 is. But just in case, that's the part of the Voting Rights Act of 1965 that required certain states, mostly in the South, that had a history of discrimination, to get any kind of ballot electoral change cleared with the Justice Department or a special court before it was enacted. So we all just refer to Section 5.
Sorry.
But just, no, that's good for others. Go ahead, Rick.
I just want to make a brief observation that I think ties both the John Roberts point together as well as this debate, which is I think Joey Fishkin of the University of Texas was the one who pointed this out. If you look at the first sentence of Shelby County, written by John Roberts, it's about state sovereignty. It's not about the right to vote. It's not about the struggles that African Americans went through in the South primarily to be able to get their right to vote. But if you look at the first line of the McCutcheon case, the most recent Supreme Court case by on the campaign finance area, also written by John Roberts, the first sentence is about democracy, and it's about the rights of donors to be able to have influence over their representatives, and that's a perfectly appropriate way. And so I think that's a kind of a look into the mind of John Roberts. He's quite offended by the idea that the state might limit money. He's quite offended that the state might limit money in politics, but he doesn't seem to have a problem with states limiting access to the ballot.
Does anybody want to jump in one last time before we open it up to everyone?
Just make a very quick comment, which is, states' job, it's the job of the states both to limit access to the ballot and to, make the ballot available to those who are eligible to vote. I don't think anyone would disagree that it's a balancing act, that you can't be obsessed with fraud, but on the other hand, you can't be obsessed with making voting so easy that you permit fraud. The state has both roles, and so I just wanted to basically make that same point, that it's not like one of those roles restricting access is invalid and the other is valid.
Great, thanks. Okay, lots of time for questions, and just wait for the mic. Can you see that gentleman over there? Okay, great.
I was most interested in the discussion about the constitutional crisis. And I was always interested in the fact that the Supreme Court did not even talk about the constitutional process for deciding who will be president. There is a process. Indeed, we've gone through that process before. Neither the plaintiff nor the defendant in those cases in Bush v. Gore raised that issue that I'm aware of, and it was never discussed by the court. And I would like to know, it seems to me that if that process went through, the Florida legislature would appoint electors. There would be perhaps other people who would show up and say they were electors. They would go to the House of Representatives. Why did the court decide that it was so important and so prestigious that it should cut off the process called for in the Constitution?
Oh, Walter, you want?
I think the court was aware of the process. It was in the briefs that there was a process under the 12th Amendment for dealing with this. The court, though, thought that the violations of the Equal Protection Clause called on it to step in because there was an individual right at stake. So it wasn't that the court was unaware of the 12th Amendment. They were quite aware of the 12th Amendment.
The other thing I'd point out is, you may remember, I remember Saturday morning having CNN on. It was early in California when
This was the day of the
the
stopping the
yes,
counts,
this is
December
after the Supreme Court, after the Florida Supreme Court had ordered the recount. Judge Lewis holds a late night meeting, and the counting starts the next morning. And then, so we're watching the counting. They're holding up the ballots, and the next thing you know, flashing on the bottom of the screen, Supreme Court issues a stay. And I think about this line in Justice Scalia's stay concurrence. So the court doesn't explain why it issues a stay, but Stevens dissents, and Stevens dissents prompts Scalia to write a concurrence. And in the concurrence, he talks about a cloud cast over the legitimacy of the election that would come from ballots being counted that shouldn't be counted, and then there being a reversal potentially by the Supreme Court. And whether you agree or not, I think what animated what was going on among the conservatives on the court was the fear that Gore would have been chosen through this recount that Gore had asked for as the winner, and it would have fell to the Supreme Court to say, no, that count was no good, and that would have precipitated the crisis. And the court was trying to avoid that, the kind of popular illegitimacy that would come from a president whose choice would have been directly reversed by the Supreme Court.
I think there was a genuine fear on the court about crisis. I mean, I remember feeling it before I knew whether the Supreme Court was, I was gonna like the result or not like the result. I felt like we were hurtling towards a constitutional crisis just because there were so many different angles. And in theory, it might have worked out democratically, but in theory, it might have dragged on long past January 20th. I do want to point out that courts often will jump in to prevent chaos. It happens on both sides. I mean, I'm reminded of the voter ID cases where I can think of at least a couple where the court said, we think the ID procedures are okay, but we're too close to the election at this point, so we're going to enjoin them for this election, and they can take place in the next election. You could certainly make an argument that that's not a proper role for the court, that the court should let things proceed, and if it looks like there's not enough time to implement things and the chaos is getting worse, then jump in. So, it happens on both sides, and I'm not even going to say it's whether it's right or wrong. I mean, perhaps the Supreme Court should have let it go further. My argument is more that once it did jump in, its decision was certainly a plausible one.
Walter, did you want to say something, or did you have a question?
Just on the constitutional, one definition of activism, Curt, is deciding an issue that is allocated to some other branch of government, rightly or wrongly. And I do think the 12th Amendment argument was serious, that if you had just let Florida run its course in its state Supreme Court, the Florida legislature may well have then voted to award a new set of electors for George W. Bush, and that would have gone to Congress. The Constitution provides that the ballots are opened in front of a joint session, and that there then is a procedure for voting on each if there is a challenge. It would be complicated, let me say, and this might have concerned someone like O'Connor, because it was going to be the new Senate, but the old vice president. So Al Gore would have presided, and if everybody voted the party line, I was involved in what the litigation would be over whether the Florida legislature could choose the electors after the fact. It may well have come down to which ballot envelope Al Gore chose to be the one to call up, the Vice President Gore as the presiding officer of the Senate. So, I mean, the court might have thought, I think it and Shelby County are alike in this sense. They both reflect a profound contempt of Congress, I think, on the part of this court, whether that's right or wrong. In striking down the Voting Rights Act and assuming that, of course, we cannot leave this for Congress under the 12th Amendment to decide how to count the ballots. And just one last point. Rick's notion that we have these partisan election systems now, they're not similar in the sense that those who are trying to make it easier for people to vote are not as bad as those who are trying to make it harder. And Curt, there's not even any plausible argument or even fictitious argument about fraud when you deliberately do what North Carolina did and severely cut back on the number of days of early voting. That just makes it hard for people who don't have cars to get to the polls. Eliminating Sunday voting, cutting back on voting, there's no fraud there. That's just a matter of making it hard. Something I never thought we'd do in this country.
Stuart?
Can I?
I'm sorry. Yeah, go ahead.
I certainly don't disagree with everything you say, but I'm always troubled by the definition of judicial activism being not deferring enough to the democratic branches, because it all depends whether there's a basis in the Constitution for the federal government getting involved. I mean, I would say many of the Supreme Court decisions that progressives love the most involve the federal government or the federal courts getting involved in things which had traditionally been thought of as under the state domain. Of course, that doesn't answer the question about whether in this case, the Constitution commanded that the Florida Supreme Court not get involved in the way that it did. But I mean, I think that's a much closer call. But I just wanted to make the general point about what's judicial activism.
Stuart first. Hold on, Stuart. Wait for the mic.
Hi, my name's Stuart Taylor. I have a question for Professor Hasen, prompted by something you said earlier. Let's suppose the Supreme Court had taken a pass in the last go-round and had let stand the Florida Supreme Court decision, and forget about who would have won. How do you think the Florida Supreme Court decision would have looked, or does look to you, in terms of its legitimacy and avoiding any appearance or reality of partisan bias?
Well, I don't think that the Florida Supreme Court did a very good job in terms of, for example, allowing the only the let me get this right. Only the overvote. Only the undervotes. Sorry, so memory's fading. Only the undervotes, not the overvotes, to be counted. I think what should have happened is there should have been a complete statewide recount. I also think that the fact that the Florida Supreme Court did not respond to the first case that Pam talked about earlier made the Florida Supreme Court look like it was not respecting the Supreme Court. But the Florida Supreme Court was hamstrung, as Pam said, by this McPherson versus Blacker theory that that legislature means only the legislature, and it can't even include the Constitution of the state of Florida, which guarantees the right to vote, and can't include any other processes. And I think it's interesting that just last term, the Supreme Court decided a case out of Arizona where they rejected the parallel meaning of legislature in the context of initiatives. So can you have an initiative that in Arizona that establishes a redistricting commission that would apply to Congress? The court said, yes, legislature doesn't just mean legislature. It means the legislative process, which includes the initiative process. And Kennedy voted on that side, which I think is interesting. So what the Florida Supreme Court should have done but felt hamstrung from doing is establish a standard and say, pregnant Chad, no, or establish a uniform standard for counting these ballots. There should have been a statewide recount. I don't know who would have won that. I actually think, based on the Newark data, that there's a good chance that Bush actually would have won that. But even so, I don't think the Florida Supreme Court looks very good. I think they look just as ideologically driven as the U.S. Supreme Court.
Yes, you, sir. The mic. Yes, you do. Thank you.
I have a comment and a question. I was in Florida on that fateful Saturday when the votes were stopped on behalf of the candidate who did not pick a cabinet. And I've also been involved in most of the major recounts over the last 30 years. And it's been my opinion, in my observation at that time, that the Bush team made a calculated attempt, successful to some extent, to slow down the counting and to turn the recount into a farce, or to appear as a farce, so that the Supreme Court, if it eventually took it, which it did, would be spooked by the counting. And I think if you look at other recounts over the years where you don't have the Electoral College sort of looming ahead, and the states are allowed to complete the count, such as the Frank and Coleman recount where I was, and others, that when there's no limit, that those are usually completed to the satisfaction of most everybody. That they're thorough. Yeah, they took too long, but people generally feel that the outcome was a just one. So that's my comment. My question is, what's the opinion on how Bush v. Gore has impacted recounts as opposed to some of the other observations that have been made? Do you think it's been helpful? I mean, I can say that as someone who was an attorney in the Franken recount, that the court did specifically look at Bush v. Gore and consider it. But I'm wondering whether or not you think in the end it's been a good thing for recounts, or it's really not had any impact.
Thank you.
One thing to say is that recount, which many people, but not all people, think was a fair recount, took 9 months, which we could not afford.
You're talking about the Minnesota
the
recount?
Minnesota recount, the
Yeah.
Frank and Coleman race.
Right.
And so one thing we learned is to do it right. It takes a really long time. I mean, it was great. The counting board was up there. It was all on TV, public access TV. You could watch the ballots. You could see how they were deciding test votes. They had a tripartisan commission, tripartisan court. Leave it to Jesse Ventura to appoint some third-party judges. But the problem is you have maybe 7 weeks or less to do it in a presidential count. And so the American Law Institute, under the leadership of Ned Foley and Steve Huffner, is actually trying to develop recount standards that could apply in the event of a close election within that window of time. And it's very hard to have fair procedures in that time.
Recount itself was actually done by January 3rd, and then the rest of it was legal.
Sure, but you would need that too, right?
Then it would have gone to Congress.
Yes.
Yeah, I mean, just two very brief observations about this. One of them is there are two ways of ensuring equality in a recount and compliance with equal protection. One is to have very detailed standards, and the other is to have all the ballots going through the same person applying a more general standard. And those are two different mechanisms. Different states have different ways of using that. That is, some states have very precise rules about which ballots can be counted and which not, and others simply send the ballots through a process where at the end of the day, they're all of the ones that are contested still are viewed by the same person. The other just observation to make is that I think one of the differences between the strategy of the Bush lawyers and the Gore lawyers in Bush versus Gore was, I think, that the Bush lawyers were thinking from the very beginning that the U.S. Supreme Court was going to decide the case. And their entire strategy was developed with the idea of building the case and framing the case to appeal to Justice O'Connor and Justice Kennedy. And I don't think that the Gore lawyers thought initially that this case was going to the U.S. Supreme Court and that they were going to decide it. And so one of the lessons that's come out of this is you need from the very get-go to be asking yourself, if this case goes to the U.S. Supreme Court, how do we appeal to wherever the kind of median justice is at the time it gets to the Supreme Court?
That's so true, and I remember when Ted Olson and his team first asserted the equal protection challenge that so many people were surprised and thought, how could this ever go anywhere? And it was exactly what went somewhere. Curt, did you want a final thing before we ask another question?
Yeah, I wouldn't agree that most people think the Minnesota election was decided fairly. I think, again, people are split as they always are with these things. I mean, certainly most Republican lawyers I know don't think it was decided fairly. But, I think that in terms of recounts, Bush v. Gore has probably been a positive thing. I think we all sort of naively thought of a recount as something completely objective, and afterwards, I don't think anyone thinks of it that way. And when I say that it's not objective, I'm not just talking about the politics, just that there is a right answer. I mean, who's to say what the right standard is for Chads when you haven't specified the standard beforehand? So it's subjective both in the neutral and I should say it's subjective in both the neutral and the political sense. And I think that's awareness of that has made recounts be scrutinized more, has just increased general awareness about the importance of election administration. And I think that's a good thing.
Another question? Yes.
Two related questions. First, do you think that the Bush v. Gore case has politicized the judicial appointments process? Clearly, if suddenly justices can determine who's the president of the United States, would have an impact. And the second question is, do you think that Supreme Court justices are less politicized or more politicized than local judges? And I'm including judges. My own perception is that local judges are far more politicized than Supreme Court judges. Have a winner-take-all judicial accountability system where you have everything and there are reputations to lose at the Supreme Court, but you can get away with almost anything at a local level. Nobody is paying attention.
At that. I think it depends what you mean by politicized. I think if you mean politics in the sort of parochial sense, then yes, it's more politicized at the local level. But if you mean politicized in the sense of highly ideological, I think it's more so, at the federal level, just because that most of those cases that reach the Supreme Court are so highly ideological. As to whether judicial nominations became more politicized, I guess it'd be hard for me to believe that, given that they were already so politicized. Some people dated back to Bork. I mean, I think that's putting way too much on the Bork nomination. My own personal view is that it's just that we've given the court so much power and the ability to decide so many issues. Much like what Rick was referring to with Justice Kennedy, where he feels he has to decide every issue, that, once you give him that much power, there's going to be tremendous fighting over it. And that certainly goes back more than 15 years. So no, I don't blame Bush v. Gore for that.
Rick, briefly, so we can get maybe one or two questions in quickly then?
Yeah, so I'm no expert on public opinion. And so I don't know how much Bush versus Gore has to do with it, but I could say two things. One is the legitimacy of the Supreme Court in public opinion polls has been going down, whether that's Bush versus Gore or a whole host of things, controversial opinions on the left and right. The other thing is we're now in a period of time where all the conservatives on the court are Republican appointed and all the liberals are Democratic appointed. This is new, right? This is new territory in the modern era for us. And so even though I don't think that Justice Scalia or Justice Ginsburg wake up in the morning and think, how am I going to help the Republican or Democratic Party? But they are ideologically very different. But now what happens is you can say the Republican Supreme Court majority did this, or the Democratic justices did that. And I think that's going to, in our highly polarized times, that's going to further politicize the court, even if it's all about ideology and not really about helping the party. Bush versus Gore is the rare case where you might see it as helping the party, and we all do the counterfactual, what if it was Gore versus Bush? Would the same facts would have come out the same way? I have no idea. But I do think that that's a big concern.
There's somebody in the back? Yes? Yeah. Yes. Great.
Yes. I was wondering if I'm not familiar with the case. I didn't read the actual case. I do remember the presidency, though, of Bush was president, I believe. So I didn't know if it was a class action. I guess it was. The woman, was it dismissed for a lack of standing, or was it on substance? It was dismissed on the substance. I don't think it was procedural because they probably endured till the end, since the Voting Rights Act continues to be reauthorized, except for maybe this last Supreme Court term. So I just want to know what happened at with the case Gore, because this is Bush v. Gore, but I thought there was a case Gore maybe v. Bush.
Maybe what you're thinking. We were addressing Bush v. Gore, the broader case, but you might have been thinking a little bit about what Judith was referring to with the plaintiffs against Harris, who was the Secretary of State there, where she was talking about the actual violations they found on the ground.
And that case was a class action. The lead plaintiff in the civil rights, voting rights case was the Florida state branches of the NAACP, but we also had individual plaintiffs from throughout the state who actually were not able to cast a ballot, all of whom were African American, living in various counties throughout the state. And that case, actually, we did a lot of discovery, but then the case was settled on all of the claims.
Great. Time for one last question? There you go. You got it. Mike? Oop, there it is. Thank you.
Hi.
You're on.
I'm interested in one point that was made earlier. First, a statement that was made by Justice Scalia during the oral arguments in the Palm Beach County case, and that is that citizens do not have a right to suffrage. And then later in the Bush v. Gore opinion, that citizens do not have a right to vote for President of the United States. And what that means for us as citizens, how that's been reflected in the laws that have been passed by Congress and by state legislatures since the case has been decided, and what, if anything, we can do about this reality that we actually don't have a right to vote.
Great. Pam, you want to start? And everybody just take
So-
one last minute.
Okay, so the backdrop to this is the Supreme Court, in a case that upheld the exclusion of women from the franchise in 1875, declared itself unanimously of the opinion that the Constitution doesn't confer an affirmative right of suffrage on anyone. most of what the Constitution says is phrased in the negative. You can't deny people the right to vote on account of race. You can't deny people the right to vote on account of gender or inability to pay a poll tax or the like. I actually think that, as is true of a number of other rights that are not enumerated in the Constitution directly, we do, from long practice, have a constitutional right to vote, and a different Supreme Court than the one we have now would recognize that and would enforce it in the way that the Supreme Court recognized and enforced that right when it held in Harper against State Board of Elections that the Virginia poll tax was no good and the like. So I think a lot of this is changing the public discussion about the right to vote. And that changes who gets elected, and who gets elected changes who gets nominated and confirmed for the Supreme Court. And that's why elections have consequences. And the largest consequence of Bush v. Gore is we find ourselves in the current political moment. But that moment could change. Or to quote George Bush himself, I believe we are on an irreversible course towards more freedom and democracy, but that could change.
Judith, you want to take a minute, and then we'll let the rest of our panelists take a minute.
Sure. So I think going back to what Pam said earlier about the way in which courts have treated the so-called right to vote, and looking at a balancing of interests between the voters' interests and the state's interests, and quite frankly, often finding on the side of the state. And not applying strict scrutiny in cases regarding election matters. And part of what, from Advancement Project standpoint, that we actually do advocate for is a constitutional amendment for a right to vote. There is a bill that was introduced by Congressmen Pocan and Ellison to establish an amendment. It is a follow-up to what Congressman Jesse Jackson Jr. had been doing for a number of years, introducing such an amendment. And we think that is important because, first of all, we do need to tighten the review that the courts have, but also to establish some national standards around voting. And then third is also to reimagine what it means to participate in our democracy. And so we think that we have to fix this issue because voters, I think, since Bush v. Gore, really it has eviscerated the way in which courts treat the interests of voters. And often what we have had to do, Advancement Project has filed several lawsuits against voter ID. We are lawyers for the North Carolina NAACP in the case against McCrory in North Carolina over the voter suppression law. And often what we find is that the courts give so much weight to the state and the interests of, it's cost too much, or it's administratively inconvenient, and so we want to cut back on all of those hours, and for early voting, et cetera. And so we think we have to end this question around the right to vote once and for all and amend the Constitution, because too often we're having to look at state constitutions. In Pennsylvania, where we won voter ID because we looked at the state constitutional right. In Missouri, we've been fighting against voter ID and winning because of the state constitutional right. So we need to fix the federal Constitution.
We've got 1 minute before our red light goes on. Curt, thank you.
I actually have a question for my fellow panelists. Certainly Bush v. Gore, and I guess going back at least to Reynolds, the Supreme Court, made it clear that the legislature really can choose whatever method it wants for electors. When you guys talk about a constitutional right to vote, would you see that as overriding what the court said in Reynolds and Bush v. Gore?
Well, I don't support a constitutional right to vote. I think it would be counterproductive, and I wouldn't want to put that in the hands of the current Supreme Court, so I can't answer that. I would say that the solution to more voting is political agitation and fighting for voting rights state by state. I think that's the only way to deal with it right now.
Thank you, everyone.